Hi, this is Alan Gassman, and it is already 12:33 on Tuesday, November 5th, and I'm very glad to have our special guest today, Diana Zeydel, talking about decanting, a new look at an old friend. And I know that a lot of you know Diana. We have a lot of attendees today, a lot of people who know a lot more about this stuff than I do, and it's going to be a really super short, right-to-the-point presentation. We've emailed you these PowerPoints, and of course you can see them on screen. Please feel very free to use this new estate tax law summary with your clients and your practice. As you see, for 2014, we're now at a $5,340,000 lifetime exemption amount. This next slide, you can see that your FICA FUTA wage base now goes up to $117,000 beginning January 1st, up from $113,700. And then if you're going to show your clients their protective trust logistical chart, you can show the estate tax exemption amount beginning next year, $5,340,000. So for those of you who haven't put these together yet, please feel free to use them. If you'd like this as in an Excel document or in a Word document, just let me know. I'll be glad to send it. But now on to our program. And like I said, today we have Diana Zeydel, and we've got a great bio here. I mean, if you ever want to just live vicariously through somebody who has done it all, especially in the tax and estate planning world, that is Diana. Unfortunately, Diana was unable to go to any Florida universities, so she had to go to Yale undergraduate and Yale Law School, and then the New York University School of, the LLM program in tax at the at NYU. She's a shareholder at Greenberg Traurig. She's a member of the Florida, New York, and Alaska Bar Associations. That's very interesting. And she's a member of the Board of Regents and the immediate past chair of the Estate and Gift Tax Committee of ACTAC, among many, many other things. So welcome, Diana.
Well, Alan, thank you very much. And joining the Alaska Bar, the only purpose for that was that I'm drafting enough trusts for my clients in Alaska, and even though I always retain a real Alaska lawyer to make sure that I'm doing what I should be doing and not doing things I shouldn't be doing, still, I just wanted to make sure that nobody can accuse me of practicing law outside my licensing jurisdiction. But in any event, and Alaska is, of course, one of the states that does move its law forward in a way that is interesting to look at, especially from a Florida perspective, because Florida has very proactive law, and those of you who practice in Florida will be happy to know that Alaska has, in a number of cases, copied our law, and copied provisions of our statutes, even in the decanting area. Introduction to decanting. What is decanting? All of you know what decanting is. Decanting is essentially the opportunity of a trustee who has discretion to distribute property to beneficiaries rather than to distribute that property rather than directly to the beneficiary, to distribute it to a trust for the benefit of a beneficiary. The first statute was the EPTL 10-6.6, the New York statute, and the motivation for the act, of course, was generation skipping tax. Because once we had a GST exemption and an opportunity to allocate GST exemption to a trust and cause that trust to forever be free of transfer tax, well, people looked around and said, well, wouldn't it be great if we could have a trust for a really long period of time as opposed to having a trust that may terminate at stated ages or terminate at some point or event that is different from the longest period that the applicable rule against perpetuities would permit. So the New York decanting statute was essentially motivated by GST, and the purpose was to allow the trust to be extended. And the basic requirements of the original statute were very similar to what the law currently is in Florida, which is that you need a trust that has absolute discretion in the hands of the trustee to distribute principal. And then the law would have permitted the trustee to exercise that discretion in further trust. Decanting statutes, lots of them. Some of you may be surprised by this list, but there are 20 states now who have something, some statute about decanting. Not all of them. It's a robust, comprehensive statute. I would say Florida's sort of in the middle there, and I know that there is a committee that's been formed under the Florida Bar to look at decanting and the possibility of elaborating our statute, being a little bit more articulate about trusts perhaps that have ascertainable standards and whether those can be decanted and that kind of thing. But the more recent statutes like Virginia, Illinois, even Ohio, have an approach to decanting that doesn't exclude trusts that have an ascertainable standard. The general thrust of those statutes is that if the trust has an ascertainable standard, you have to maintain it, or at least you can't pursuant to it, that you can't go way off book when it comes to a trust where the settlor has created some limitations on the trustee's authority to distribute corpus. Original case, of course, the Phipps case, the Florida case, which allowed a trustee with absolute discretion to distribute in further trust for the benefit of the primary beneficiary of the trust, and the endeavor there was to allow the primary beneficiary to receive a testamentary power of appointment, and that testamentary power of appointment was planned to be exercised in favor of the primary beneficiary's spouse, who was not a beneficiary of the original trust. So it's quite a lot when you think about it. I mean, this is a Supreme Court case that allowed the trustee to engage in a decanting that permitted a beneficiary to exercise a power of appointment in favor of a non-beneficiary. And the thought there was, well, the trustee had absolute discretion to distribute corpus for any purpose. And so the trustee could have distributed that corpus to the beneficiary directly, at which point that beneficiary could have deflected the property to his spouse. So the idea is that because the trustee has that much discretion, absolute discretion, that the lesser included ability to distribute in further trust was there. You see what the Fifth Court held, which for a rule gleaned from the foregoing and other cases of similar import, is that the power vested in a trustee to create an estate in fee includes the power to create or appoint any estate less than fee, unless the donor clearly indicates a contrary intent. So that's very important. That default rule is that it's an included power. And you would need language in your trust or some evidence, if it could be brought in as extrinsic evidence, that the donor intended something to the contrary. The state of Spencer is an Iowa case, not as clear in terms of what the decanting authority there is. It looks more like a power of appointment. And Wiedenmayer, which is a case that, as we'll see when we talk about the recent Massachusetts case, Wiedenmayer was essentially an indirect decanting, but because the trustee took this action, it's viewed as support, and Morse v. Kraft, which we'll talk about in a second, relied very much on Wiedenmayer and its analysis. So the most recent case we have, and let's go back one slide, let's just spend 1 second on Wiedenmayer and what the case said about the authority to distribute. Because in Wiedenmayer, what happened is the trustee distributed to the beneficiary on condition that the beneficiary would take that property and immediately settle it in further trust. And the endeavor was to exclude a couple of the remainder beneficiaries who apparently were giving the beneficiary quite a horrible time. And when the Wiedenmayer court analyzes the trustee's authority to do this and whether or not in the best interest of the beneficiary, the court has essentially said this: the son's best interest is not defined in his father's trust indenture. The expression is not limited to a finding that distribution must be in the son's best pecuniary interest. His best interest might be served without regard to his personal financial gain. They may be served by the peace of mind already much disturbed by matrimonial problems, divorce, and the consequences thereof, which the new trust, rather than the old contingencies provided for in his father's trust indenture, will engender. And then the court says, of what avail is it to rest one's best interest on a purely financial basis and without regard to the effect upon a man's mind, heart, and soul, very touchy-feely stuff, if the end result would produce a wealthier man but a sufferer from mental anguish. So the idea is that best interests include also your best personal interest, not just financial interest, but what is going to make you feel good about this trust and the interest in this trust. And in this particular case, where the trust was going to land in the hands of remainder persons who presumably were, very adverse in the beneficiary's dissolution of marriage, that those people would be excluded was something that the court felt fell within the scope of best interest and something the trustee was permitted to take into account, engaging in this decanting maneuver. Morse v. Kraft, which is the Massachusetts Supreme Court that's the most recent analysis of decanting, the court spent a tremendous amount of time citing Fifth, but appears more inclined to follow Wiedenmayer. And it is clear that the Boston Bar Association tried very hard to push the court to a much more general statement of decanting authority. That essentially, distribution authority in the hands of the trustees includes, like Fifth has said, includes the lesser authority of distributing in further trust. But the court really didn't want to go all the way there, although the court did permit the decanting on the particular facts of this particular case, but they were not willing to articulate a general principle that decanting is part of our common law, which I think would have been nice, but they just weren't willing to go there. They relied on the fundamental principle that interpreting a trust, you have to look at the intent of the settlor. And you get the intent of the settlor from looking at the trust instrument itself, and so the court focused on the authority to distribute for the benefit of the beneficiary as evidence that the settlor intended the trustee to have authority to distribute in further trust. But the court admitted affidavits of the settlor, who happened handily to still be around, the attorney draftsperson and the trustee, as extrinsic evidence of what was the intent. And so in order to admit this extrinsic evidence, they would have had to find an ambiguity in the trust, some way why the trust was not clear within the four corners of the document, and so there was an opportunity to look external to the trust. Then the court said a few things that we may not like very well. The court essentially indicated that if there were a more recent trust instrument that didn't draft in express decanting authority, that might create a negative inference. The idea that now decanting is a very well-known authority. We've got 20 states with statutes that deal with decanting. People know about it. So if a modern trust is written without a decanting clause in it, Morse v. Kraft leans in the direction of saying maybe that would be an indication it was intentional, because otherwise why would you not have inserted it? Now, I mean, it's obviously if your state has a statute and that authority is there, your trust instrument, which once in a while you have a little difficulty with the IRS getting them to understand that not everything is written in your trust instrument. You've got your trust instrument, and then you have common law, and then you have state statutory law, and all of that together is your trust agreement, right? So if you haven't overridden state law and you have decanting authority in your state law, obviously that's written into your trust. But if you were in a state where there was no statute, there was no governing law, common law might not get you there, is sort of what Morse v. Kraft is saying, because right now, a settlor ought to know about decanting, or at least his or her advisors ought to know about it, and maybe that means that if you don't put such a clause in your trust, you intended to exclude it. The court expressly, like I said, declined, as requested by the Boston Bar Association amicus, to recognize an inherent power of trustees of irrevocable trust to exercise their distribution authority by distributing property in further trust, irrespective of the language of the trust. So the Boston Bar wanted something very broad, and the court declined to agree. So that tells you that I think that we are in the world now where you either incorporate by reference your state law, if you have a decanting statute, or you write yourself a clause. And one of the reasons to write a clause, and sometimes with an old trust where I still do a decanting under Fifth, because remember our statute says that it doesn't override the common law and it's not intended to override Fifth, is because of the notice requirement and because of having to give notice to qualified beneficiaries and maybe not wanting to do that and maybe not being able to get a waiver and maybe not wanting to wait the 60 days. So those are the reasons why you may still find a decanting clause in your trust agreement handy. And I would say, look around at the statutes that are a little more articulate, but you might want to expressly say, if you mean it, that it permits trust to be extended, it permits powers of appointment to be granted, et cetera, because, just to be clear about settlor's intent, if we're in that universe where that's going to matter to a court and you want to be sure that trustees have this flexibility, I think writing a little bit more about the types of authority that are permitted and what additional powers are permitted, I think is useful. There is a new case also in Nassau County, and this was a decanting under the New York statute as recently amended. And the New York statute has become quite a tour de force in drafting. If any of you have looked at it, it is quite articulate. It has a couple of surprising things in it. And one of the surprising things, at least to me, is that the statute says that if you do not have, if no beneficiary under the trust has a power of appointment, then by decanting you may confer one, but it's got to be a wide open power of appointment, a so-called non-general power, meaning you can't leave anybody out except the beneficiary's estate, creditors, or creditors of the beneficiary's estate. And it's almost as if what they're saying is if you're going to confer a power, you have to have been as close to willing to distribute the property outright to the beneficiary as you could possibly be. And the only reason you didn't give the beneficiary the property outright is maybe asset protection or tax consideration, but not because you wouldn't have done it. You had to have been prepared to turn the reins over to the beneficiary in terms of the ultimate disposition of the property. If, however, your trust agreement has a special power of appointment in it, the New York statute says you can't change it, which to me is a little odd, right? Because you think that a settlor who confers a special power might be one of those who is more inclined, not less inclined, to give the beneficiary some say about where the property goes. But in this particular case, the New York statute is quite clear that you have this sort of split. The Alaska statute does not adopt all of that, even though it has the same author. But the New York statute has some peculiarities. One of the things that the more modern statutes do is to permit you to convert a trust that is not a special needs trust into one, so that you can, if your beneficiary happens to become a special needs person, that you can preserve government benefits. So that was more or less the fact in Ray Kraft, where you had a beneficiary who was the recipient of a trust created by the beneficiary's grandparents at a time when the beneficiary was an infant, and the extent of the beneficiary's disabilities were not yet known. The trust, as you'll see here in these notes, the beneficiary became special needs and would have been entitled to government benefits but for the terms and conditions of this trust. And the trust was a wholly discretionary trust until age 21, but then at 21, as many of these old trusts do say, it required the distribution of income, and principal was to be distributed at 25, 30, and 35. So loss of all benefits with that kind of dispositive language. The Attorney General comes in and defends against the decanting, and I suppose maybe, I don't know, I don't recall right off the top of my head how the Attorney General came to be at the party, but the Attorney General was at the party in the case. And the Attorney General comes in and says, look, the trustee has no authority to decant under the statute. Why does the Attorney General say that? Because reads the statute closely and says you can't abridge any mandatory payment rights, and this trust has mandatory payment rights, not right now because the beneficiary was under 21, but in the future. And because there are mandatory distribution rights in the future, you can't decant at all. And the court says then no trust would be decantable, or most of them wouldn't. I mean, you would really be back to only an absolute discretion trust can be decanted. Any trust that has mandatory stated payments, you couldn't ever change them. And the rest of the statute in New York is quite clear that that's not the case. That if right this minute you have absolute discretion to distribute corpus, even if in the future the trust says distribute principal at 25, 30, and 35, you can decant right now if you have absolute discretion. So the court disagrees with that proposition. Then the Attorney General says, well, by the time you decant, this is a self-settled trust. And if it's a self-settled trust, you've got to include a payback provision. This has become one of those self-settled, qualifying trusts. And so this trust has now become the sort of trust that requires the payback provision. Here's what happened. The beneficiary was going to become 21 on May the 7th. They sent the decanting notice under the statute on May the 1st. And the decanting notice in New York requires a 30-day notice period that can be waived. So on May the 2nd, beneficiary's father comes in and consents and waives the notice period. And the trust instrument says, happily, trust instrument says, parent or guardian can act on behalf of the beneficiary if the beneficiary is a minor. And so the question now becomes, well, is the father's waiver of the notice and the notice period of 30 days valid, so the decanting could take place essentially immediately and, importantly, before May the 7th, when the beneficiary would attain the right to mandatory income? And the court says, yes, the trustees are authorized trustees, and that means, trustees who are permitted to exercise decanting authority. The trustees complied with the statute. The consent by the parent was effective to shorten the 30-day notice period. The decanting was effective on May the 2nd, prior to the time the beneficiary became 21. The appointed trust is an effective third-party special needs trust, and there's no requirement for a payback provision in the appointed trust. I think Cross is very significant from the standpoint of this is one of those circumstances where decanting can change the beneficiary's life in terms of availability of government benefits, government programs, and all the rest. And if you couldn't do this, essentially, the trust assets could not be protected. And so this is an area where I think decanting is very, very important and a good authority to consider. Other reasons to decant: correct a drastic error. Oh my goodness, we don't wish to have those, but once in a while you see something that you just wish were different, and if decanting is available, it can be very handy to fix something before it becomes a problem. To avoid an adverse tax effect, such as if you want the trust to be a qualified for Chapter S trust, by decanting, you might be able to get the provisions in there to have your single beneficiary with an income interest, etc. Extend the time or event when a trust will end. The New York statute is quite articulate that that's permitted. I think in Florida it's also permitted, but we may want to adjust our decanting statute to expressly so provide. I don't think that there is any question you can do it, but it's always nice to have express authority. Add or eliminate a census provision, always helpful. Change the status of the trust. Once in a while, you'd like your trust to be administered somewhere else, or maybe you would like to exit a jurisdiction with an income tax. For example, there may be reasons you wish to change the governing law, and that can be handy. Avoid a state or local tax. There are, you will all know that because New York, for a period of time, which is not tax beneficial, but for a period of time, the New York statute required court approval, which, as you remember, when the IRS issued its notice asking us, here are all the things we're thinking about in the decanting area, what do you think? I think it was 2011-101, and we all sent in a lot of comments, and then we've had nothing but radio silence since then. But one of the things they were worried about or asking about is, what difference does it make if there is a requirement for court approval, if there's a requirement for beneficiary consent? How does that change the tax consequences of decanting? And we have always thought that you shouldn't require court approval and you shouldn't require beneficiary consent, because then you're sort of walking into potential tax issues. The New York statute briefly in its inception did require court approval, and for that reason there's a little body of case law in New York that's helpful. And so if you're looking for some authority of what a trustee can do when the trustee has absolute discretion in the way of decanting, got some nice things in New York in terms of case law. Some of them were expressly to avoid New York real estate tax and these kinds of things, and the court approved that. And now we have this new case on being able to decant for purposes of creating a special needs trust. Grant a presently exercisable or later exercisable power of appointment. We do have one case in New York that says, and this was under the old law, where decanting, like Florida, was restricted to absolute discretion, that if you have an ascertainable standard, even though it says you can distribute for health, maintenance, support, and education as the trustee and the trustee's absolute discretion determines, it's still a standard. And so under New York law, you couldn't decant, and under the Florida statute, I don't think you can't either. You have to worry about if you have a presently exercisable power of appointment in the hands of a current beneficiary of the trust, and you do something that the trustee even or the beneficiary exercises that power in a way that reduces the discretionary interest in the trust, the IRS seems to think there's a gift tax consequence to that. And there is even a more recent PLR than this 2002 PLR. There's one in 2013 that talks about, the notion that, look, if you have a discretionary interest in a trust and something takes place where your interest is reduced, that has tax consequences. Now, in the most recent private letter ruling, the IRS says it may be that the value of that interest is very small or negligible, but nevertheless, we're not going to tell you it's zero. We think there's a taxable gift there. So that doesn't necessarily always solve the problem, and so an independent trustee exercising decanting authority can be better. Other possibilities for decanting is to make a trust a grantor trust, or reverse that and turn off grantor trust status. One of the best ways that I think decanting is used is where you've got one of these old-fashioned trusts that is a pot trust with a lot of people, a lot of beneficiaries sharing in the same trust estate, and where they're no longer on the same page, either in terms of distribution policy or in terms of investment policy. And decanting can be a very nice way to separate people from one another so that they have interest in independent trusts, and you don't need to go through the modification reformation round. If you have decanting authority, the trustee can do it, which is much easier. Income tax, gift tax, estate tax, GST tax, what are the tax concerns with decanting? I think the better part of it is we have a series of IRS rulings that tell us that for income tax purposes, if you decant the entire trust, it's the same trust. It's not a new trust. It's the same trust. And when we decant the entire trust, unless we are changing the tax status of the trust, meaning we're taking a grantor trust to be non-grantor, or the reverse, or we're creating a QSIP, or we're doing something different. If we're not changing the income tax status of the trust, I treat that as the same trust, and I use the same tax ID number. Gift tax concerns with decanting. That's where, that's the IRS has kind of asked us those questions, right? Can a beneficiary be making a gift by standing around with their arms folded while the trustee commits a decanting? And I think the answer to that really takes us back to the trustee has absolute discretion and is exercising decanting authority in that context. Then I think we're in the same land as what if the trustee made a big distribution to one of the discretionary beneficiaries? Have we ever thought that that's a taxable gift by the other beneficiary? Well, no, unless the trustee is engaged in arbitrary and capricious conduct. So I think it's the same here. Decanting is the same as the exercise of any fiduciary authority, which is if you had a legitimate ability to stop the trustee from doing it, you could object, and you had a likelihood of success. Because remember, in the gift tax world, the law is that you may have a cause of action, but you're allowed not to proceed if you have virtually no chance of succeeding, and it's not a gift if you don't. So if somebody owes you money, but they are judgment-proof, the fact that you don't pursue that loan is not a taxable gift because you have made a business judgment that you could not collect. I think decanting is the same, that if the trustee is within their discretion and they're doing something for a reason, they have a reason. It's not arbitrary and capricious. You can't stop it, and therefore it's not a taxable gift not to attempt to stop it. Estate tax, I think it's the same issues there of whether you have, are exercising or denying a general power, that kind of thing. Otherwise, I think you're okay. And GST tax law, again, is this a qualified severance or what is going on? If the trust is already wholly GST exempt, I think you're okay. And if the trust is not exempt, and we've done this a couple of times, and you want to slice off an amount of the trust that allows the transferor to allocate GST exemption late to that trust, the income tax law and the GST tax law are going to support that being a separate trust, and you are permitted to allocate only to that trust, and it doesn't become a blended trust for any reason, as long as that trust is a separate trust otherwise. So if your state statute or the trust instrument permits you to slice that off as an independent trust, and it is that for tax purposes because it is that for property law purposes under your state law, and I think that then you can go about making a late allocation of GST exemption and doing that kind of planning. So decanting, I think, the trouble that we all have a little bit is that we really, really wish the IRS would give us some guidance, because then we'd have a better sense of what to do in terms of our various statutes. But I'm not that optimistic that decanting guidance is forthcoming anytime soon. I would not give it, anything like the current plan year. I just don't think it's on the radar at the moment. And I'm not sure that we'll ever get guidance, because it's a difficult thing for the IRS to get their mind around. Therefore, I think that, what you're left with is good analysis and flexible drafting, and think clearly about what you're doing. I think a trustee that has absolute discretion is always going to be the safest, because the property law is that unless the trustee is engaged in arbitrary and capricious conduct, that exercise of absolute discretion is going to be valid under the law. And if it's valid under the property law, beneficiaries can't oppose it. And if they can't oppose it, they can't be engaged in taxable transfers. The great thing about decanting is that you can preserve or even enhance the tax benefits. And I do think this recent case out of New York that talks about the ability to convert a trust to a special needs trust that is a third-party special needs trust to protect those assets for the family and then particularly for the benefit of the special needs beneficiary is an important one. And now, we have some recent authority about how that works and that it does accomplish its goal. So that's all I have.
Wow, that was a lot, and that was excellent. Very good analysis. I can see why you're such a great writer, too, because when you speak, every sentence comes out very clear, very concise. So congratulations on that. If anyone has any questions whatsoever, you can email Diana at zeydeld@gtlaw.com. That's zeydeld@gtlaw.com. Diana, thank you so much. Now, I just have a couple other little things to mention. Next November 14th in Tampa, we are hosting a seminar, either breakfast or dinner, on the BP claims issues relating to the matching of income and expense decisions. Very fascinating stuff, especially if you have an accounting degree or you're a tax lawyer. Intellectually, this is very interesting, and it's very crucial if you have clients that have BP recoveries and they have claims in process, or your own claim if you live on the Gulf or you have a practice on any county that joins the Gulf of Mexico. Also, last Wednesday, October 30, my partners and I gave a B&A webinar on year-end tax planning for advisors. Anyone who would like the outline for this, just let us know. We'll be glad to send it to you at no charge. If you want to view the webinar, you can email me or Mark Carrington at bna.com, and there's a promotional discount. Wednesday, November 20 at 12:30, Jerry Hesch, Larry Katzenstein, Edward Wynarski, myself, and my partner Ken Crotty are going to give another Bloomberg B&A on planning for self-canceling installment notes and private annuities, how not to get burned. Anyone who has an interest in this, please let us know. If you can't attend, I'll be glad to send you the materials at no charge. Or if you want to attend, let us know and we can get you a promotional discount. I have an idea call here that we're going to discuss called the SCRAT, where you would do a self-canceling installment note under an LLC owned by the grantor and then transfer that LLC to a GRAT. So we're going to be talking about that during the webinar. It may get shot down, it may survive, but you can read the description here on page 23 if it's of interest. And we have a chart here that we've been developing with the other speakers on skins versus private annuities versus GRATs, and this will pretty much be the outline for the discussion. Finally, Jerry Hesch has been very, very generous with me helping us develop an estate tax planning software program that quite candidly is working very well. We distributed it to a lot of the people who attended at Notre Dame, and we're just looking for more beta users. If you'd like to get a 15-month free subscription, no obligation whatsoever, it even comes with a timeshare, just email estateview@gassmanpa.com and you'll get an auto response. Click on the auto response. The software will come right up, and it enables you to put the information in 3 separate tabs: client tab, financials tab, life insurance tab, and then it will run different scenarios for you. You won't believe how fast it is. It is really quick, and you can dial data up and down, and it can simultaneously keep track of no planning with or without portability, whether using a bypass trust, annual gifting, discounted annual gifting, and life insurance. It's coming along well. We'd appreciate anybody who might want to be a beta user. It has a lot of other features that I won't waste your time with. But the newest feature is we do have Jerry's installment sale calculator fully up and running. You enter the information you see on the top of the screen, and it instantly gives you the estate tax savings based on year of death. It shows you the effect of grantor trust status. It allows you to toggle off grantor trust status in any year that you decide you want to. It allows you to do a conventional low interest note or a self-canceling note, and it gives you pretty good results, a pretty good screen that you can show your clients. So please feel free to let us know if you'd like to participate in that. No obligation. We're just looking for people to help us design this software. It's been a lot of fun. Okay, going back to the beginning, there you have Diana's contact information. Diana, I can't thank you enough for a great presentation.
Well, thank you, Alan.
Okay, everybody, back to work. It's all billable from here, and have a fantastic afternoon.